Citizens of the gallery, there is a phrase litigants love to say, "I'll see you at trial." Maybe you will. Filing a lawsuit does not guarantee a trial. Surviving a motion to dismiss does not guarantee a trial. Completing discovery does not guarantee a trial. At some point, the court may look at the evidence and ask a brutally simple question. Is there actually a genuine factual dispute here that a jury needs to decide? If the answer is no, the court may produce a judgment without ever having a trial. In this session we examine summary judgment, when the evidence, or the lack of it, can end a case before anyone takes the witness stand.
Summary judgment is a procedure allowing a court to decide a claim or sometimes part of a claim without a trial when there is no genuine dispute over a material fact, and the moving party is entitled to judgment as a matter of law. In federal civil litigation, the principal rule is Federal Rule of Civil Procedure 56, and nearly every word in that standard matters. The question is not whether the parties disagree. Litigants disagree constantly. The question is whether they genuinely disagree about a material fact. That distinction is the heart of summary judgment. This is where people often become confused. We previously discussed motions to dismiss. A motion to dismiss commonly attacks the legal sufficiency of the complaint near the beginning of litigation. For example, even assuming the properly considered allegations are true, has the plaintiff stated a legally viable claim? Summary judgment ordinarily occurs later, often after the parties have conducted discovery. Now the question changes. The court is no longer simply asking, what has been alleged? It is asking, what does the evidence actually show? That is an enormous difference. At the pleading stage, allegations can carry the case forward. At summary judgment, allegations alone may no longer be enough. Eventually, you need evidence. Suppose I sue someone over a car accident. We disagree about whether the defendant was wearing a blue shirt or a green shirt. That is a factual dispute. But unless shirt color somehow matters to the legal claim, it probably is not a material factual dispute. Now suppose we disagree about which driver had the red light. That could determine liability. That fact is material. A fact is material when it could affect the outcome under the governing law. Summary judgment does not disappear merely because the parties can identify something they disagree about. The dispute must matter. Now we reach the other important word, genuine. A genuine dispute exists when the evidence is such that a reasonable fact finder could return a verdict for the non-moving party. That principle was explained by the United States Supreme Court in Anderson v. Liberty Lobby, Inc., 477 U.S. 242, 1986. The court is not supposed to conduct the trial while deciding summary judgment. It does not ordinarily decide which witness it likes better. It does not simply choose one side's story because the judge finds it more persuasive. Instead, the question is whether sufficient evidence exists for the dispute to require resolution at trial. That is an important limitation. Summary judgment screens out cases that do not require a trial. It is not supposed to replace a trial when genuine material factual disputes remain. The party requesting summary judgment is called the moving party. The opponent is the non-moving party. The precise burdens depend on the issue and circumstances, but the moving party must establish the basis for the motion and show why Rule 56 permits judgment. Then the opposing party must respond with appropriate evidentiary material showing that a genuine dispute requiring trial exists. This became especially important in Celotex Corp. v. Catret, 477 U.S. 317, 1986. The Supreme Court explained that a party moving for summary judgment does not necessarily have to produce evidence disproving the opponent's entire case. In appropriate circumstances, the movant can point to the absence of evidence supporting an essential element on which the opposing party will bear the burden of proof at trial. That can be devastating, because litigation eventually reaches a point where saying, "I know what happened," is different from demonstrating, "I have admissible evidence from which a fact finder could find what I say happened." By the time summary judgment arrives, discovery may have produced a substantial record including deposition testimony, documents, electronically stored information, admissions, interrogatory answers, affidavits or declarations, and other materials identified under Rule 56. But simply attaching a mountain of documents does not automatically create a genuine dispute. The evidence must actually relate to the material issue. Rule 56 requires parties to support factual positions by citing particular parts of the record or otherwise showing why the cited material does, or does not, establish a genuine dispute. Courts are deciding legal motions and are not supposed to conduct archaeological expeditions through thousands of pages hoping to discover someone's argument. This distinction is critical. At summary judgment, courts generally view the evidence and draw reasonable inferences in favor of the non-moving party. But that does not mean every assertion must be accepted. There still must be evidence capable of creating a genuine dispute. In Matsushita Electric Industrial Co. v. Zenith Radio Corp., 475 U.S. 574, 1986. Another major Supreme Court summary judgment decision, the court emphasized that the opponent must do more than show some metaphysical doubt about the material facts. Taken together, Salatex, Anderson, and Matsushita are often called the Supreme Court's summary judgment trilogy. Their central lesson is straightforward. Trial is necessary when evidence creates a genuine dispute requiring a fact finder, and trial is not necessary merely because one party insists that a dispute exists. Suppose one witness says, "The light was red." Another says, "The light was green." And both accounts are supported by competent evidence. Now we may have a genuine factual dispute. Who is telling the truth? Whose memory is better? Or which witness should be believed? Are classic fact-finder questions. Summary judgment ordinarily is not the place for resolving genuine credibility contests. That is why the distinction between evaluating whether evidence exists and weighing that evidence is so important. The judge determines whether there is something requiring trial. The fact finder determines which properly presented version ultimately prevails. Summary judgment does not always end the entire lawsuit because Rule 56 permits a party to seek judgment on a claim, defense, or part of one. Imagine a case involving 5 separate claims. Perhaps 2 have no genuine factual dispute and can be resolved as a matter of law. The remaining 3 still require trial. Resolving the first 2 can dramatically simplify the case. So, summary judgment can narrow litigation even when it does not end it. Some common misunderstandings are, if I have any evidence, I automatically get a trial. No, the evidence must create a genuine dispute concerning a material fact. If the parties disagree, summary judgment must be denied. Again, no. The disagreement must be genuine and material. Summary judgment means the judge decided who was lying. Not necessarily. A proper summary judgment ruling asks whether a trial is legally necessary based on the evidentiary record. My complaint says what happened, so that proves my case. A complaint contains allegations. At summary judgment, the case has moved beyond merely pleading allegations. Evidence matters. Summary judgment violates the right to a jury trial. No, the procedure determines whether there is a genuine factual dispute for a jury to resolve in the first place. Trials are expensive. They consume judicial resources. They require witnesses, attorneys, jurors, court personnel, exhibits, and substantial preparation. If no genuine dispute of material fact exists, and the law entitles one party to judgment, conducting a trial would serve little purpose. But the opposite is equally important. When genuine material factual disputes do exist, summary judgment should not become a substitute for trial. That balance is the entire point. Summary judgment reveals something fundamental about litigation. A lawsuit begins with allegations. Discovery investigates those allegations. Depositions test them. Documents may support or undermine them. Witnesses commit themselves to testimony. Eventually, the legal system asks, what can actually be proved? That is why summary judgment often becomes a moment of reckoning. A compelling accusation may survive pleading. A confident narrative may dominate social media. A litigant may sincerely believe every word of their case. But Rule 56 does not ask who tells the most compelling story. It asks what the evidentiary record can support. So when someone confidently announces, "I'll see you at trial," remember, first, the case has to get to a trial. Summary judgment stands between discovery and trial, asking whether a trial is actually necessary. Are the disputed facts material? Is the disagreement genuine? Is there evidence supporting the required elements? Could a reasonable fact finder decide for the non-moving party? If yes, the dispute may belong at trial, and if no, the law does not require a jury simply to confirm what the evidentiary record has already established. Lawsuits may begin with allegations, but eventually, allegations have to meet evidence.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.